All right, you are all set, and Miss Holly would like to talk to you in the hallway real quick.
Absolutely.
And good luck to you. Thank you. All right, good. Sure, if I received back the signed copy of the notice of right to appellate review. All right, I have a young lady at the jail. What is your name, please?
Jessica Hamilton.
Jessica Hamilton?
Yes.
All right, I'm gonna rename you. The
Okay.
audio in that room is not that great. And I believe Mr. Murphy is your attorney, right?
Yes.
Do you need to talk to Ms. Hamilton?
I spoke with her yesterday, Your Honor, so I'm ready to go on the record.
All right, Ms. Underwood, do you need, just for an update, Mr. Madison was approved for recovery court, I believe. So do you need a breakout room with him while I take care of Ms. Hamilton?
Just briefly, yes, Your Honor. Thank you.
Okay. So, Mr. Madison, I am going to open up some breakout rooms and give you a chance to speak to Ms. Underwood.
Okay.
So you'll have to join it because I think you're in a regular room. To Ms. Underwood.
Can you tell him I'm in here?
Your dad is here too, Mr. Madison.
All right. Thank you.
He's always here for you. So,
Yeah, he always is. Yes, he is.
all right. I'm going to open that room. Go ahead and join it. All right. So Mr. Murphy, Ms. Hamilton is here. So Ms. Hamilton, I'm going to need you to like scoot up and speak louder because the audio in that room kind of is wonky.
Okay.
All right. This is in the matter of the people of the state of Michigan versus Jessica Sharice Hamilton. We have three files. 20-19943FH, 20-19942FH, and 20-19941FH. I have Matthew Murphy appearing on behalf of Miss Hamilton, and today is the date and time set for a bunch of sentencings. So let me get her paperwork. All right, where is she? It's over here. Oh, I found it. Different pile. Okay, so, all right, I have Matthew Murphy appearing on behalf of Miss Hamilton, and I see a couple prosecutors, but they must not be on this one. So I do show, here I got a letter from Mr. Post. I just have the forensic fluids report. All right, I have a forensic fluids laboratory report. The date of collection was September 5 of 2024, and this was sent off to the labs. On that day, Ms. Hamilton tested positive for amphetamines, methamphetamines, cocaine, and then subcategory would be cocaine, benzoyl, and then she also tested positive for fentanyl. So I guess we're lucky she's even standing here or sitting here today. Mr. Murphy, did you receive a copy of the pre-sentence report?
Your Honor, the last pre-sentence report that I got, I mean, there was one prepared for sentencing that was scheduled a year ago.
I have one that was sent to you on 10/10 of 23. It was prepared a year ago because nothing's changed.
That's the one that I have and have reviewed, and we provided a copy to Ms. Hamilton and spoken with her about that. Yes, I didn't know if there was one. So there's no update.
No. So Mr. Murphy, so Ms. Hamilton, have you had an opportunity to read and review the pre-sentence report?
Yes, I have.
All right. Have you had an opportunity to discuss this with Mr. Murphy?
We did yesterday.
Okay, good. And Mr. Murphy, were there any issues in your discussion with Ms. Hamilton?
Yes, Your Honor. Ms. Hamilton, now this had occurred last year as well. Her account of things are not what I recall, so I don't know if there were things that
For
occurred.
what?
Her recollection of what had occurred, what she had occurred in her court cases, wasn't what I had recalled. I didn't know if there were things that occurred when I wasn't here, if she was talking cases I wasn't on. I provided Ms. Hamilton last year as well as this year copies of the Register of Action for all the cases, the 3 cases that I have her on. I have assigned on her the Register of Action from the district court as well as from the circuit court, as well as the police reports for those files. But again, she's insisting that she didn't enter a plea on the matter, that this is incorrect, that she was desiring to withdraw her plea. At this point, if there is a plea on the record for them. Now, as I provided the Register of Actions, it shows that there was a plea, I believe, to no contest to a possession and then a resisting obstructing officer. And then that plea involved, again, there was supposed to be, I believe, no upfront jail, but there was some missed court dates. So there was incarceration because of that. She posted bond on some cases, but then she's got a case down in district court. Still now, I believe, that's a retail fraud that we weren't appointed to because apparently she wasn't facing jail time on it. But of course, she was held in jail on the bond on that case. But it's still not in we're not appointed to that still, I believe. But again, you can see the confusion here as well, Your Honor, on my part, trying to figure out what, as she's recounting, she didn't do any of these, that these cases were, I don't know if she wanted to say on the record what she believed, what she was saying happened, because again, it's kind of hard for me to follow what she's saying occurred, because she is insisting that Judge Schaefer had reduced a file from a resisting and obstructing down to a fleeing misdemeanor charge. So, Your Honor, again, she's asking to withdraw the plea. At this point, I guess I would argue that it might not be knowing involuntary. And also there's pending contempts that she wishes not to enter a plea of guilty on and set those for hearings.
Okay, so Ms. Hamilton, my records show that you did enter a plea on those files as a no contest plea due to lack of memory.
No, I told him I didn't want to plead guilty to those because I'm
Well,
not
ma'am,
guilty.
I'm talking now, not you. So you did enter a plea and you knowingly gave a plea that day. If you want to withdraw your plea, that's fine.
Yes, I want to withdraw my.
I'm talking now, not you.
All right.
But understand, the maximum penalty you're facing is prison, and these files stack because you were on bond when you committed some of the new offenses. So, and you have that new file. So if you want me to withdraw your plea because you say it wasn't knowingly given, that's fine. My next available jury trial will be January, and I will make sure to get you on the January schedule, and you will remain in custody because you absconded for a couple of years. So, or you can be sentenced today. So
Go
you're
ahead and
sentencing.
sentence me then.
I'm sorry.
Go ahead and sentence me.
No, because your attitude is kind of
I'm just tired of
iffy. So
messing
I'm
with
going
it.
to adjourn this out a week and give you more time to talk to her. So Ms.
Okay.
Adams, can I get another sentencing date?
All right, Friday, October 18th at 8:15.
So I'm going to set this over to October 18th at 8:15, and that'll give you more time to talk to Mr. Murphy, and perhaps when you come back, you'll make a better informed decision one way or the other. All right, thank you.
Thank you.
Yeah.
Have a great day.
You too. All right, Mr. Madison, Ms.
ma'am.
Underwood, are you ready on Mr. Madison? Oh, you're on my Zoom, so I was looking down, but you're here. All right. Yes,
I'm sorry to interrupt. I have 2 matters in Mr. Olsaver. So if the Jackson jail is not available, can somebody let me know when they are?
I have a Joanna Fortuna, so let me find out who that is. Jackson kind of always logs on with different stuff.
Actually, you know what? Miss Underwood is the attorney for one of my matters, so disregard.
Okay. Yeah, I got her. She's mine. All right, this is Mr. Love, Mr. Madison. All right, I have somebody logged on named Joanna Fortuna. Can I ask what case you're here for, please?
For Brian Steinhofer, actually.
Oh, the civil case?
Yes.
Okay, I'm not gonna hear that till 9:30.
Okay.
All right, thank you.
Okay. Thank you.
Madison, so we are on the record in the matter of the people of the state of Michigan versus John Carl Madison, file number 23-21575 FH. I have Rhonda Underwood appearing on behalf of Mr. Madison. This is the date and time scheduled for a violation of probation sentencing. Miss Underwood, have you had ample opportunity to speak with your client?
I'm sorry,
Have you had ample opportunity to speak with your client?
I have.
All right, Mr. Madison, have you had an opportunity to review the probation violation report with Miss Underwood?
Yes, ma'am.
Are you satisfied with her advice and her representation?
Yes, ma'am.
Miss Underwood, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
We do not, Your
All
Honor.
right. Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
Not that I'm aware of, Your Honor.
All right, so Miss Underwood, before the court passes sentence, is there anything you'd like to say on behalf of Mr. Madison?
Briefly, Your Honor, Mr. Madison welcomes the opportunity to participate in the drug court, Your Honor. He's been screened. He is a candidate, and he eagerly anticipates being in the drug court. I think it's to his credit that even before drug court was mentioned to him, he mentioned rehab to me and was very interested in that. I think the provision is that he served 30 days, but with release, I know Mr. Madison has served an extensive amount of time, so it's my hope that Ms. Teskey can work very quickly to get Mr. Madison a rehab bed and back here to participate in your court, Your Honor. Thank you very much.
All right. So, Mr. Madison, the recovery court program is an amazing program. There is a large team of people that work with individuals, and it's kind of wraparound services. It starts out in phase one. It's very intense, and then it kind of gets easier as you work the way through the phases. I've known you since you probably were a young teenager, and I will say that I've seen people go through this program that I thought, I don't know if they're going to be able to do this, and watch them just succeed and become the best version of themselves. So I can't rave enough about this program, but you kind of just got to give it all to it. And it's a wonderful program, but it is time consuming and it's a lot of work in the beginning. So
Right.
you would like to be a part of that program?
Yes, ma'am.
Excellent. All right. So, and let me see, Ms. Teskey, Sarah Teskey, she might be zooming back and forth.
Yep, I'm here, Your Honor.
So on the recommendation, are we going to release him to inpatient, or how do you want, does the recommendation change at all? I have release from jail to enter the program, or what is?
The recommendation, did Mr. Stevenson recommend like 90 or 120 days or anything such as that?
It said if he's eligible for the drug court program and wishes to enter into the program, he should be released from jail to enter the program. So I just didn't know how you wanted to do that. Do we?
Yes, the drug court team did recommend residential first. So
Okay.
that is what we would like to do.
Okay, and Mr. Madison, I will explain that's fairly typical. So we, what we tend to do is release people to an inpatient program. It kind of stabilizes them, gets them into intensive counseling, And then in a month or two, or whenever that program ends, then you phase out into intensive outpatient. And we found that our success rates are higher going that way for people with substance abuse issues, okay?
All right,
And the bed becomes available fairly quickly, so you won't be sitting in jail for 90 days. As soon as the bed opens, they transport you, okay?
all right.
All right. Well, let's see. All right, so it is the sense of the court that your probation will be continued. Mr. Stevenson, I will zero out the attorney fees owed.
Okay.
Okay, so I'm taking off the $450 in attorney fees, Mr. Madison, so that'll take the amount you owe down to about $950.
Alright.
Your probation will be continued. I'm gonna order that you serve 90 days in jail, but released to an inpatient program as soon as the bed's available, and that's fairly quickly, it happens. Anything else? Oh, and you must enter and complete any program that you're admitted to. You can't leave.
Okay,
You can't get kicked out, so, because that could be a violation of probation, so.
okay,
It doesn't happen very often, usually that happens, and then you have to enter and complete the recovery court program. So that'll also be an added term of your probation, okay?
yes, ma'am.
So, Mr. Madison, you do have the right to appeal this sentence, and we will send over to the jail 3 copies of your notice of right to appellate review. You can initial and date 1 copy for our records, the other copies are for you. And Mr. Madison, I look forward to seeing you in our recovery court program when you get back, all right?
Thank you.
All right, thank you, sir.
Judge, can you
Yes.
show a credit of 32 days?
Oh, and I'll give you credit for 32 days, all right, Mr. Madison?
All right, thank you.
All right, thank you. No, he's good. All right, thank you. Mr. Madison, could you let them know that I would like to see a Mr. Oglesby, it's not a person, right? Oglesby, Mr. Oglesby,
All right.
thank you. Okay, so, is there Kenneth Baker in the courtroom? In the matter of the people of the state of Michigan versus Kenneth Russell Baker, file number 20-19820FH. This is a date time set for sentencing on a probation violation. The report was done by, who did this report? Jen Walsh. Ms. Walsh, did you meet with Mr. Baker?
No, he's in the Jackson jail.
Oh, he is the Jackson jail case. All right, well, Mr. Baker has not appeared, so Ms. Adams, can we set this over to another day and try to get him from the Jackson County Jail again?
Okay.
What, and I just need the date.
Were you wanting a week out, Judge, or how far?
However long you need to be able to get the Jackson County Jail.
We could try for next Friday, 18th.
The 18th, so we'll set it out for 10/18 at 8:15, Ms. Adams.
Yes, Judge.
Thank you.
If you need me today for that, just have someone call my personal cell phone.
I know where to find you. All
Okay.
right, thank you.
Yes.
All right, so, Mr. Murphy, are you ready on Mr. Schmidt?
Yes, ma'am.
This is in the matter of the people of the state of Michigan versus Nicholas Thomas Schmidt, file number 23-21502FH. I have Matthew Murphy appearing on behalf of Mr. Schmidt. Mr. Murphy, this is a misdemeanor case. Well, it was pled down to a misdemeanor. And did you receive a copy of the PSI?
I have, Your Honor.
And have you had a chance to review that with Mr. Schmidt?
I have, Your Honor.
All right, Mr. Schmidt, you reviewed the pre-sentence report and discussed it with your attorney.
Yes, Your Honor.
Are you satisfied with Mr. Murphy as your attorney and the advice that he has given you?
Yes, Your
All
Honor.
right, Mr. Murphy, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor, we reviewed the criminal history and it's all accurate or to mention.
Okay. And I show that. All right, before the court passes sentence, is there anything you'd like to say on behalf of your client?
Your Honor, Mr. Schmidt, I believe will perform well on probation. We ask the court to adopt that recommendation, suspending the jail time. Obviously, as I believe this was, an agreement worked out between the prosecutor and the court, I believe, discussed the matter. I believe this is appropriate. I would also ask the court to consider, Mr. Schmidt has been on bond for a while. He has been on bond conditions. He hasn't used or had any violation. He hasn't used any alcohol. So I'd ask the court to consider removing the no alcohol condition. He doesn't drive. And obviously, again, he's just been abstaining from alcohol. He doesn't have an issue with it moving forward. So he would abide by the orders court if, if the court ordered it. I was just asking the court, basically for my own thing, because I don't want to have unnecessary restrictions on my clients. So I'd ask the court to consider it. I don't think it's necessary moving forward, Your Honor. So, but other than that, I believe it performed well. He'll abide by any order the court gives. So thank you, Your Honor.
Okay, Mr. Schmidt, anything you want to say on your own behalf?
No, Your Honor.
Okay, so, under the health section, are you currently taking that medication?
Yes, yes, Your Honor.
All right, and you shouldn't be consuming alcohol with those medications.
Yeah, yes, and I barely drink as it is.
Okay.
Maybe once in a blue moon on a special occasion is about it.
Okay. All right, and anything else you want to say?
No, Your
All
Honor.
right, in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines which don't apply here, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, potential for reformation, vindication of law, and the protection of society. Per the plea agreement that was reached between your attorney and the prosecutor's office, I will place you on probation for 12 months. I will order that you serve 365 days in the jail, but I will suspend that upon any violation. I don't know, did you ever spend any time, a night in jail or anything?
Yes, Your Honor.
How many days?
3 or 4, Your Honor. I'm not quite positive.
All right, I'll give it credit for time served of 4 days. There is $750 in court costs. And let me check this. I'm gonna say $100 fine, $50 in state costs, and $75 crime victim rights fee. There's a $30 per month supervision fee while you're on probation, $60 if we have to put a tether on you. Understand that during the term of probation, you can't use any illegal controlled substances. Prescriptions that you might test positive for something for need to be provided to the probation officer so they know that one of those medications might give a false positive. Not to behave in any threatening or intimidating behavior, and no contact with KS during the term of your probation. This is deferred under 769.4A
Yes,
if
Your
he
Honor.
successfully completes probation.
Yes, Your Honor.
And this did involve alcohol. So that's why there's a no alcohol clause. Do you understand?
I understand that. Your
So
shoes
for
are no
12
fault.
months, since you don't drink anyway, it's 12 months. So no alcohol as well. Plus you shouldn't be drinking alcohol when you're taking that medication. They can search in your house, your car, your personal property if they have reasonable cause to believe you violated your terms of probation. Do you understand that?
Yes.
Okay, so I don't think I've forgotten anything. So you need to report to district court probation. What day is the report day?
Yeah, that's Miss McCarron usually, I think usually Thursday, I don't,
Is that right, Miss Spade?
you want me to, I can take it down there right now.
No.
Usually Wednesdays.
Wednesdays,
Wednesdays
all
is the
right,
report
so next week, not this week. Next week, you have to report to district court probation, go in on a Wednesday morning.
Okay.
And between 8 and 10, all right, and then they'll meet with you and have you sign your terms of probation and everything, okay?
Okay.
Now, you do have the right to appeal this sentence, and my bailiff's gonna hand down to you your notice of right to appellate review. You're gonna initial and date one copy for our records, the other copy is for you, and if you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days, all right?
Now, as long as I do my probation out correctly, nothing goes on my record, right?
Right?
Misdemeanor, everything's gone.
Yeah, just,
Thank you,
yeah,
thank you, Your Honor.
you're welcome.
Thank you, Your Honor.
All right, thank you. All right, and the record should reflect, I received back a signed copy of the notice of right to appellate review. Miss Adams, I'll have to fill out his probation terms later. All right, so you're here, what's your name, please? Okay, and that's Mr. Dagger Margosian, I've lost him. Yeah, he's in, are you Mr. Oglesby? Oh,
Yes.
you're right there. I'm sorry, he's on Zoom and he was all quiet, so why don't you come on up? All right. And in the jail, are you Mr. Oglesby?
Yes.
Does anybody need to talk to Miss?
I have Mr. Oakley, we're ready to go here.
Okay, all right. Let me double check this one. All right, Mr. Dagger Margosian, in the matter of the people of the state of Michigan versus Jamie Ellen Vanzo, number, file number 23-21503FH. This is the date and time set for sentencing. I have Michael Dagger Margosian appearing on behalf of Mr. Vanzo, and I have Phoebe McClure appearing on behalf of the people. I don't have anybody here that is here to speak. So I did see the victim's rights coordinator, but I don't have anybody in the courtroom that's a victim on this case, Miss McClure, even though I received a letter saying they might.
Just for the record, I believe this one was a sentencing that was moved. We notified the victims of the new sentencing date, and they agreed that they heard that sentencing date and are not here today. But I am appearing because there was a sentencing memo that was filed.
Okay, I have a sentencing memo that was filed by both of you. So I have one by Miss Underwood.
No, it would be Mr. Dagger Margosian and then myself.
Oh, that's the wrong file. I don't have, I have your sentencing memorandum. I don't have one. I'm not denying Mr. Dagger Margosian filed it, but for some reason, I don't have it. So, Mr. Dagger Margosian, do you have sentencings down the hall?
No, just this.
All right, so I'm gonna have to send someone to find that. So, Mr. Vanzo, why don't you have a seat again, all right?
I can
Sorry
email
about
you my
that.
copy, Judge. I have it
Okay,
handy. I mean, you at least would get it quicker.
yep, that's fine, and I'll just need to review it real quick. All right, so Miss Underwood, Mr. Oglesby.
Thank you, Your Honor.
His side. this is in the matter of the people of the state of Michigan versus Marcus Gamba Oglesby, file number 24-21867FH. I have Mr. Oglesby appearing via Zoom, and I have Rhonda Underwood appearing on behalf of him in person. This is the date and time set for sentencing. Ms. Underwood, did you receive a copy of the pre-sentence report?
We did.
All right, have you had an opportunity to review that with your client?
Yes, I have, Your Honor.
All right, and Mr. Oglesby, you've had a chance to review this with your attorney?
Yes,
Are you satisfied with your attorney and the advice that she's given you?
yes.
Okay, and I'm gonna need you just to speak up a little bit for me because that room doesn't carry sound very good, okay?
All right.
All right, thank you. Now, I do have a sentencing memorandum that was filed by Ms. Underwood on Mr. Oglesby. I did not receive a response from the people. So, Ms. Underwood, I just wanted you to know I've got that. So, Ms. Underwood, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Well, pursuant to my sentencing memorandum, Your Honor, on the first page, when it says, I believe you have it in the sentencing and when it says pending investigation, Eaton County, Your Honor, I find that supposition and that to be so far afield that it should be stricken. If this has been ongoing and if there were charges, they would have brought them. I think it's much more prejudicial than probative. And it goes to the statement in the recommendation or in the second statement, Your Honor, and I
Okay.
think they both should be stricken.
So
Out
this,
of fairness to Mr. Oglesby,
okay,
because there's been nothing proven and nothing even charged.
okay. So, Mr. Stevenson, I know we were here previously. Do you have an update on that?
We can just strike that from the record. I have
All
no
right.
issue with that.
Very good. So we will strike that, Ms. Underwood.
Both things, Your Honor.
So, there was the statement,
Yes,
pending investigation parole violation out of Eaton County
yes,
and under investigation for an incident that took place on April
Yeah.
13 of 24, in which he allegedly fired a weapon at a DFAT or a parole absconder investigator.
thank you.
We can strike that as well.
Okay, so Mr. Stevenson has no objection and neither do I. All right, anything else you wish to explain or challenge?
Nothing else, Your
All
Honor.
right, does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
Not that I'm aware of, Your Honor.
All right, now he was on parole at the time that this offense occurred, is that correct?
That is correct.
All right, and so he does show 0 days credit because of him being on parole.
I'm aware of that, Your Honor.
Okay, all right.
And I, in fairness to Mr. Oglesby, I think the court should be aware of that too.
Yeah, and I explained that to him. All right, the probation department calculated the minimum sentencing guidelines to be 5 to 23 months. Do you agree with that?
I do.
And does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
Not that I'm aware of, Your Honor.
All right. Before the court passes sentence, is there anything you'd like to say on behalf of Mr. Oglesby?
There is, Your Honor. In looking at this incident that we're here for today, this was an absolute low level resisting, Your Honor. Mr. Oglesby couldn't get his hands out from beneath him while he's asking them, yelling them not to shoot him. Mr. Oglesby was in no way violent. He did not have a weapon. Mr. Oglesby, the absolute minute they picked him up, complied with everything they asked him to do. I think the recommendation of 16 months, Your Honor, is clearly a reaction to what we just had stricken from the record. And I don't think it's appropriate for this case. I think if Mr. Oglesby is on a parole holder, he also has the pending parole violation, Your Honor. Those, they can take care of Mr. Oglesby with, but on this resisting and obstructing, I would hope the court would consider the absolute low end of the guidelines and allow Mr. Oglesby to proceed with other courts if they wish to proceed with them.
Okay. Mr. Oglesby, is there anything you want to say on your own behalf?
No, no, ma'am.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criterion reasons for the sentence are the nature and gravity of the offenses, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. Mr. Oglesby, you are very young to have the record that you have stemming back to your juvenile history. I mean, you're employable, you've had employment, you're married, right?
Yes.
You know, you have a lot of things going well for you, but you're lucky you're not dead from, you know, being shot at or anything else. You really need to think about your life going forward. It's a sentence of the court that you will serve. $16 months to 2 years with Michigan Department of Corrections with 0 days credit served. There's a $130 crime victim rights fee on count 1, a $68 state cost on count 1, and a $68 state cost on count 2. The sentence, because you were on parole, is consecutive to your parole violation, but these will be served concurrently. So they will serve together. This one, right? Why are you looking at me like that? It's consecutive to his parole violation because it has to be, because he doesn't have any credit for time served.
I think.
And then these will run together. So, sir, you do have the right to appeal this sentence, and we're going to send over to you your appellate paperwork. I just need you initial and date 1 copy for this file, and then the other copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. Okay? Thank you, Mr. Oglesby. You're all set. All right. Is that all you have with me this morning?
I believe it is, Your
Okay.
Honor. Thank
All
you.
right. Thank you.
Is that on both counts, 16 years, but they're being.
16 months.
16 months, right? Okay, thank you.
She said 16 years. I said, no, it wasn't 16 years. All right. Mr. Glazier. You're here on Mr. Collins.
Mr. Collins, is there a Robert Love too?
There is, but I haven't seen him.
Yeah.
Did you already speak to Mr. Collins?
Yes, I did.
Do you want him brought down?
Sure.
And it's really weird. Mr. Love always shows up for the longest time, and then I don't know. So I'll call it. In the matter of the people of the state of Michigan versus Robert Love Jr., also known as Robert Matthews, file number 20-19918FH. Date and time set for sentencing on child support failure to pay. So I have John Glazier on behalf of Mr. Love, and I have Mr. Owuda Coker appearing on behalf of the Attorney General. So I have a stack of paperwork I received for today. It looks like there was an audit done. it looks like in 2023, there was a total of 900 that was due, but 1850 that was paid. And then in 2024, we got a payment in January and February for $125 or a charge of 125, and he paid 937.04. So it looks like from June of 23 to February of 24, I mean, he was paying substantially large amount. Now, I also received, where'd it go? There we go. And I think, yeah, so then I also received on November 30th of 2023, a letter, and this may be really why. I got something from front of the court that says on Danielle Nieto forgave everything owed to her from Mr. Love. And then I have, so I'm not even sure what, I have some paperwork from the probate court about a guardianship of a juvenile. I mean, I just, it's odd. So I don't know if he thinks, like Mr. Awuda-Coker, what is the arrearage now? Do you know? It's just really strange.
Yes, Your Honor, I have an arrearage of $4,635. And for the case that I have with Mr. Love, I have the custodial parent being Brenda Dibble. So
Yeah, I also have,
okay.
yeah. I had, so Mr. Glazier, I don't know what to say at this point. I think it's odd that he's not here, especially when he had a history of making payments. So I also show a June 14th audit that says Erica paying Brenda. All right, so Erica paying Brenda Dibble and Robert paying Brenda Dibble. Are there two payees on that file? Because the child's in a guardianship? Oh, you're muted, Mr. Awuda-Coker. I'm sorry.
Yeah, I believe there are two payees, Your Honor. I believe payments are currently going to Brenda Dibble now. I know that the case is second. I know that the case is currently charging $125 a month. That's the extent of the information that I have.
Right. So Mr. Love appeared every single time for the longest time. And I'm just wondering, I'm curious because who's this? No, that's not him. So Mr. Glazier, I guess I could do one of two things. I can adjourn this for you to try to find Mr. Love, because I'm wondering if there's some confusion about the arrearage being forgiven or whatever it might be. So I could adjourn this for 30 days for you to try to locate him. I just think it's strange that he made all those payments and then ghosted us, because he usually.
That's fine. I'll have somebody try to get a hold of
He showed up forever, Mr. Awuda-Coker. Is that all right with you?
Yeah, I have no objection, Your Honor.
All right, Miss Adams, could I get a November sentencing date from Mr. Love?
Okay. November 22nd at 8:15.
November 22nd at 8:15. So if anybody knows Mr. Love, if we have him contact Mr. Glazier or the court. Okay, all right, so Mr. Glazier, thank you, and we'll see you back on that one, all right? Okay. All right, Mr. Collins. Thank you, Mr. Owuda Coker.
I'm also hearing Darius Collins as well, Your Honor.
Okay. Well, you can stay then.
Okay.
I'll let you stay. Find this. Okay, so this is in the matter of the people of the state of Michigan versus Darius Dwayne Collins. I have John Glazier appearing on behalf of Mr. Collins today. We have 3 files. We have 24-21767 FH, and on that file, I have Mr. Glazier and Mr. Owuda Coker. And then we have file number 24-21798 FH and 24-21799 FH, which I have Mr. Glazier appearing on behalf of Mr. Collins, and I'm just gonna throw Mr. Sneed in there because he's in my court right now, appearing on behalf of the people. So this is a date and time set for sentencing. Mr. Glazier, you received a copy of the pre-sentence report.
Yes, I have, Your Honor.
And Mr. Collins, have you had an opportunity to read and review the pre-sentence report?
Yes.
And Mr. Owuda Coker, you received it as well?
Yes, Your Honor.
Okay, so Mr. Glazier, do you wish to explain or challenge the accuracy or relevancy of any information in this pre-sentence report?
No, Your Honor.
Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
I don't think we had any prior stuff.
No, yeah, no juvenile record, no prior misdemeanors, no prior felonies.
That's
No.
all right.
All right, so one case is a misdemeanor on file number 24-21799 FH, but the other 2 are felonies, and the guidelines on file number 24-21767 FH were calculated to be 0 to 17 months on the failure to pay child support. Mr. Owuda Coker, do you agree with that computation of guidelines?
Yes, Your Honor.
And Mr. Glazier?
You said 0 to 6, right?
17.
0 to 17, yeah, I agree with that.
Okay.
The other one's 0.
It is, yes. So and then on file number 24-21798 FH on the attempted larceny in a building, the guidelines were calculated to be 0 to 6 months. Do you agree with that calculation guidelines? All right, before the court passes sentence, Mr. Owuda Coker, is there anything you wish to say relative to file number 24-21767 FH?
Just an update, paragraph 12 under the Department of Corrections recommendation lists the arrearage at $19,017.14. And just as of today, Mr. Collins has an arrearage of $26,911.20.
All right, we will update that. Sir, how long have you been in jail?
Couple months.
Okay.
115 days is what.
So
That was last one.
you have to right now do the paperwork that you send in front of the court to get kind of a stay for the time you were incarcerated.
Okay.
Because they may take off that charging amount for those months because you've been in a considerable period of time.
Okay.
But if you wait 6 months to do it, they're not gonna do it.
Okay.
So I think the jail has something that you can send over. Okay, all right,
Who do I ask for that? Ask the sergeant?
probably,
Okay.
yeah. Okay, so anything else, Mr. Owuda Coker?
No, Your Honor.
All right, Mr. Glazier, on any of these files, is there anything you wish to say on behalf of your client?
Your Honor, just that the recommendation on the misdemeanors for a year in jail, which seemed excessive to me. Most times in a use down in district court, it involves no jail. And I guess we'd ask the court to give my client probation, give him some time here. He needs to get some counseling on drugs, and I'm sure he'll do that if he needs assistance. We have a person in my office that can help get him set up for that as well. Mr. Collins is my neighbor, so I've known him since he was a little kid. And he's not a bad kid. I think he's got mixed up with some drugs and he needs to get that taken care of. His mother's back here. She's a good lady. She comes over and talks to my wife 2 or 3 times a week. And I know she's concerned for Darius. And I think if he gets off the drugs and if he, and obviously he has been now because he's been a period of time, but hopefully he'll stay off of them. I think he'll do well, and you gotta start paying this, otherwise you're just gonna keep coming back and coming back, you know that. Oh, on the larceny of building, can that be deferred in any way? That would make his chances of deployment a little harder, but I don't know if we can defer that or not.
Mr. Sneed. So I have a question for you on the Collins file. I'm gonna say it's file number 24-21798FH. I'll let you pull it up and then I'll ask you. So let me know when you're ready.
I found it, Your Honor.
Okay, so Mr. Collins pled to a child support failure to pay, and I do have the AG here today. And then he also pled to a misdemeanor controlled substance methamphetamine. So Mr. Collins, I don't show has any prior record in terms of eligibility for 7411 on the drug case. And then also there's an attempted larceny in a building, and Mr. Glazier was inquiring as to whether or not a deferred would be admissible on that. It wasn't something that was addressed at the time of the plea. He's 36, he has 0 prior record. Mr. Glazier states that, but for a recent issue with substance abuse, you know, he probably wouldn't have these cases. So I don't know who is the prosecutor on this file to talk to regarding whether or not a deferred on the attempted larceny in a building. And I think Mr. Glazer is just asking for purposes of employment so he can start paying his child support off.
It's Ms. Wagner's file, Your Honor, and I don't know which statute it would be deferred under. So if Mr. Glazer would like some time to research that, I have no objection to adjourning the sentencing.
Like a delayed or Mr. Glazier?
I don't know, I know we've done it before, I don't know which statute it is.
So I guess we could do I'm looking here. I've got deferred judgment of guilt, delayed sentence. Assess fine, restitution. Defer entry of judgment of guilt. I mean, at this point, I've already entered the plea of guilty. I mean, I think whether or not he's eligible for 7411 on the methamphetamine case really is up to me. He has no prior record, so I think 7411 wouldn't be a reach on that misdemeanor. Would you agree, Mr. Sneed, for me?
I would agree, Your Honor, yes.
So, I mean, I could do a deferred and then change his guilty plea as taken under advisement for 12 months. And then if he's successful for that 12 or for that term of probation, then it would be set aside. Because I don't think that attempted larceny in a building would stop him from getting that's not one of the offenses that is not admissible under a deferred, Mr. Sneed?
Your Honor, I don't know the statutory basis for a deferred judgment of guilt for an attempted larceny. I don't know if one exists.
All right, so, I mean, I am more than happy to, like, I'm more than happy to adjourn this out to the 18th. There's a recommendation. I would release them today.
Okay.
And then give you some time to look at that. Would that be all right, Mr. Sneed?
No objection.
Okay, so Mr. Collins, the recommendation was for jail on the misdemeanor case and not on the felony files. So what I'm gonna do, because Mr. Glazier really is trying to help you, I'm gonna release you on a PR bond today. And I'm gonna set, Ms. Adams, could I get a notice of hearing for October 18th at 8 o'clock?
Okay.
That day is probably gonna be a busy day. But I'll get you a notice of hearing or your jail paperwork. I'll give a notice of hearing to your mom, and then your jail paperwork will have it. So here's the deal. You're gonna get out of jail today. Your bond conditions, no alcohol, no illegal controlled substances. I want you to get into NA right away. Start going to some meetings. You can do them online. You can do them locally. They have something somewhere every day. And I'm gonna adjourn this a week. And then I'm gonna drug test you next week. So no use. You've been clean for a while.
Yeah.
Don't hang around with bad people, you know, because obviously that's what happened because you've never been in trouble before and all of a sudden you are. So I'll move this sentencing, but no nonsense. Okay, and I'm gonna give you a curfew from 10 PM to 6 AM.
Leave the house.
Yeah, okay, but I want you to get a job. Okay, so you gotta go look for a job. And we'll give a notice of hearing to your mom, that way she has it, and your jail paperwork will say that I'll release you on a PR bond. I'm sorry, Mr. Woodcoker, can you come back on that day?
I think that should be fine, Your Honor. So,
Okay.
yeah.
But then I want you to show me you've got a lead on a job because you need to start paying this down, right? When you get out of jail, come right back to the courthouse, go down to front of the court in the basement of the building and say, the judge sent me to get some paperwork to try to defer my payments while I was incarcerated. Mr. or Deputy Frost, who does he get the paperwork from the jail showing his, isn't there like something they get from the jail that says?
Incarceration. Proof of incarceration. Yeah, I use that as a sergeant.
So you need to get, before you leave the jail, proof of incarceration. And then you take that down to front of the court and you talk to them about it then, all right?
That was the 18th, say, right?
Yes.
Your Honor,
Yes.
I need him to report in person to me Tuesday at 8 AM, 3rd floor of the courthouse, Circuit Court Probation, Sarah Teskey.
Ms. Teskey, I didn't sentence him. I adjourned it to the 18th.
Yep, I thought you give him a bond though.
Yeah,
Okay, so I just need him to report to me since he's on bond. Or is he gonna report to Darren?
he can report to you if you want.
Okay, I just want to touch base with him. I mean, if he's,
Okay.
does he have bond conditions with Darren as well?
No, because he's been incarcerated, but yeah, so next Tuesday at 8 o'clock, you gotta report on the 3rd floor to Miss Teskey, okay? You met her before at the jail?
No.
Not to use any illegal controlled substances and not to consume alcohol by, because I'm gonna test him when we come back on Friday. Okay.
And the curfew.
And a curfew. She got that. I think she said she got that. All right, so, all right, Mr. Collins, so you're all set. Your jail, so when you get out of the jail today in a couple hours, get your proof of incarceration, go to front of the court. Next Tuesday morning, report to Ms. Teskey, all right?
Okay, thank you.
Ms. Adams, do you want him to sign the bond paperwork here?
It's gonna take me a while, Judge, because there's 3
Okay.
files. I'm sorry.
So they'll get it over to the jail. All right, thank you. Okay, thank you. And you'll look up the statutory basis and all that for us.
Yeah, you said further delays, right?
We can't do a delay, probably deferred. So, yeah, do just a little memo on it, get it to Mr. Sneed or Ms. Wagner.
All right, thank you.
Okay, so we did that one. We did this one, we did this one, we did this one. It's weird that he didn't show up. All right. Oh, we're still here with you. Okay, let me look, Miss, I took all this paperwork home yesterday and looked at it and I didn't have that, so Miss McClure sent me that, so let me pull it up. The guidelines. Guidelines. Okay, you can come back up. All right, thank you for your patience. Mr. Sneed, are you here now on Vanzo? Is that still Miss McClure?
I'm here for that, Your Honor. Thank you.
Okay. All right, so we are back on the record in the matter of the people of the state of Michigan versus Jamie Ellen Vanzo. I now have a pre-sentence report, and I'm sorry, I know I had it before, Mr. Dagomar-Gosian, and I apologize.
No
All
problem.
right, so I'm looking at it. Mr. Vanzo entered jail. All right, he objects to conditions 3 and 4, so I'm gonna look at that. And Chris Jones, you with us? All right, so Mr. Jones, on, so I have Mr. Dagomar-Gosian filed a sentencing memorandum. Did you get a copy of that, Mr. Jones?
I did.
Okay, so the first thing he objects to is condition 3 and 4. Condition 3 must not reside, work, or loiter within a school safety zone and go within 500 feet of parks, playgrounds, etc. So Mr. Dagomar-Gosian objects to that language since he says these conditions have been removed from SORA requirement. The prosecutor's office, what did it say? He said, okay, they said the court may impose lawful conditions of probation as the circumstances of the case warrant. So basically the prosecutor says because of the nature of the offense, he is a risk to minors based on this activity. And he believes that those conditions, or she stated that those conditions would reduce recidivism. So Mr. Jones, the policy of the department, I know the language was removed from certain offenses. Does the department have, I'm just asking first, any requirements on that?
So the departmental policy is I'm required to recommend those conditions. And I confirm that. I mean, I've confirmed this with people in Lansing, and I mean, just to clarify, it hasn't been removed from the law because the courts are the only ones that can still recommend school safety zones and parks and recreation areas. So the law hasn't removed it. It's just changed it up where like parolees and offenders that are not on supervision anymore don't have those requirements. The only requirements that we have to recommend is for court supervision.
All right. All right, Mr. Dagomar-Gosian, would you like to address that clause of, or 2 clauses of your sentencing memo?
Yeah, Your Honor, thank you. Regarding conditions 3 and 4, as I stated in my sentencing memo, those conditions, my understanding is those conditions have been removed from SORA imposition. And so if the probation department is recommending those, that is basically circumventing the legislative policy of removing those, I think as recent as the 2021 SOAR amendment. So I don't think, I think because the legislative body has removed those, it would be inappropriate for the judicial branch to then circumvent that decision by imposing these.
Okay, and Mr. Sneed, do you wish to respond or rely upon the memo filed by Ms. McClure?
I would rely upon the memo, but I would just state that it's not a circumvention for a different branch of government to exercise authority, which this court has by statute that was cited in the memo. Thank you.
All right. Okay, so with regard to section 3 and 4 of the recommendation, 3 is that he must not reside, work, or loiter within a student safety zone defined as 1,000 feet of school property, developmental kindergarten through 12th grade school, unless you meet a statutory exemption. You must not go or be within 500 feet of parks, municipal swimming pools, playgrounds, childcare centers, preschools, arcades, or other places primarily used by individuals age 17 or under without prior written approval of the field agent. Obviously, there's arcades that are made for adults, because there's one in Toledo. We have to be 18 to enter. While that is not a requirement under SORA anymore for certain offenses, and obviously your client did plead no contest at the time of the plea. He pled no contest. The nature of this offense does involve inappropriate sexual contact with a minor. So I do feel that we craft terms and conditions of probation to meet the individual and the offenses. So I do feel that 3 and 4 is appropriate. So I will deny your request to remove those 2. So, all right, objection to conditions 7 and 8 in the PSI. 7 is not to use or possess alcoholic beverages or other intoxicants, and comply with alcohol testing. Mr. Vanzo, he has 1 prior misdemeanor, and I think it was a possession of marijuana in 1999, and then there is a 2017 offense that is this current offense. So Mr. Jones, I don't show any alcohol dependency or issues with alcohol, is that correct?
None that was reported, Judge, no.
Okay, Mr. Sneed, any position on that?
The people defer to the court's discretion regarding conditions 7 and 8, Your Honor.
All right, so I will remove conditions 7 and 8 regarding alcohol and alcohol testing. Mr. Dagger Margosian. All right, and okay, and the next one is that this plea was entered with an agreement with the prosecutor's office of no upfront jail. And I do have in my notes that there is no upfront jail. The recommendation is for 9 months deferred and so, or suspended. So I will grant your request on that one because of the plea offer. So we will remove the recommendation of contact, so that's on there. I'm looking for it. So the court's not going to order the 9 months delayed. What else we got? All right, so then we move on to PRV 5. Mr. Dagger Margosian objects to it being scored at 2 points. We go to my guideline book. PRV 5. Prior misdemeanor conviction or prior misdemeanor juvenile conviction. There's a 10-year gap requirement. His misdemeanor possession of marijuana charge was back in 1999. So I think that's well over the 10-year time period. That's your argument, Mr. Dagger Margosian.
It is, and I think the people agreed with that in their response.
Yeah. So we will change PRV 5 from 2 to 0. That makes the total PRV 0. And then, Mr. Decker Margosian, you objected to OV4 being scored at 10 points, as there is a lack of record support for serious psychological injury in this case under People v. Wine and People v. White, and you believe it should be scored at 0 points. And Miss Muir, hold on a second. She says that, or in the sentencing memorandum, she stated that the probation department properly scored OV4 contrary to defendant's averment. There is a record supporting serious psychological injury. The PSI specifies that victim BS suffered severe anxiety attacks when in the presence of defendant. In addition, the victim's mother sought out and engaged the victim in professional counseling. PSI page 2. And then, do we have a victim impact statement at all, Mr. Jones?
I did not receive one, Judge.
Okay. And the statements that were made to you in the process of putting together the pre-sentence report?
Information would have been provided from the police report.
All
That I
right,
received.
so okay. Mr. Dagger Margosian, is there anything you wish to verbalize further on that objection?
Your Honor, the only thing I'll add is I think the court just hit it that we don't even have a victim impact statement submitted in this, which should weigh towards not imposing any points on OV4, as we know that it's a pretty high bar to meet that, and I just don't think it's been met in this case.
All right, Mr. Sneed.
I just rely upon what's in the PSI, Your Honor. I don't think whether or not there's a victim's impact statement should weigh in favor of scoring what the court can score here.
Okay. Well, right, and People v. Erickson, 288, Mish App 192, 2010. The pre-sentence report in that case indicated that the victim suffered from depression and further issues. And the court found that OV4 was properly scored at 10 points based on information contained in the pre-sentence report and from the police report. So I am going to deny your objection to the scoring of OV4, and I will leave that at 10 points. Okay. And it doesn't change the guidelines though at all. So the guidelines remain 0 to 9 months. Is it correct, Mr. Dagger Margosian?
Correct, Your Honor.
Okay. Is that correct, Mr. Steen?
Yes, it is. Thank you, Your Honor.
Okay, I don't remember how far we got along, but let's back up a little bit. So, Mr. Vanzo, you got to read the pre-sentence report. You got to talk to your attorney, right?
Yes, sir.
And you're satisfied with him as your attorney and the advice that he gave you. And Mr. Dagger Margosian, is there anything else in your memo? I don't think so. So Mr. Dagger Margosian, he has no prior convictions other than that 1999 misdemeanor for marijuana, correct?
Correct.
And so the guidelines you don't dispute are 0 to 9 months.
Correct.
Mr. Sneed, you don't object to that either?
Correct, Your Honor.
Okay. And before the court passes sentence, Mr. Sneed, obviously I have a sentencing memorandum that was prepared by Ms. McClure, and I've reviewed that. But is there anything else you wish to say on behalf of the people?
No, thank you.
All right, Mr. Dagger Margosian, is there, and I also removed the $450 attorney fee. So, Mr. Dagger Margosian, is there anything you wish to say on behalf of your client?
Your Honor, the only other thing that wasn't specifically addressed, which was addressed in the sentencing memo, is the length of time for probation. If the court would recall, we went into chambers and sort of before a plea was entered, discussed what the terms would be, what the length would be. And while it wasn't, while there was no sentencing agreement for the length, it was kind of, we all thought that it would be there would be no reason to depart from the, I guess call it standard industry of about 2 years of probation. I see in the recommendation it's higher than that. I would just ask the court to sentence Mr. Vanzo to the 2 years. And obviously, if there are issues, the court can extend. I don't suspect that there will be any issues, but I don't see a reason to depart from that. But for an upward, I guess call it an upward departure, I think it would be appropriate for just the standard with given Mr. Vanzo's history, really lack of any history, and the age of this case and the compliance of bond and all the rest. I think a 2 year sentence of probation, again with the possibility of extension, makes sense.
Mr. Jones, this isn't one that mandates a 5-year probation term. I know some of the statutes.
It absolutely is, Judge. All sex offenses are statutorily required for 5 years probation.
It's allowable. I'm not sure it's required. It's allowable.
It's absolutely required for 5 years.
Okay, I thought so also, but let me look something up on the statute. Language,
Yeah, there's a list of offenses that show you how many years of probation it's required. Like I'll just give another example. The aggravated assault ones are the same scenario where they're required to be on for 5 years.
all right, so, okay. I know that, Mr. Dagger-Margosian, there are some that are not required, but some of these offenses do require the 5 years probation. And I know, like, I have no contest, it's a 4-year felony, right? Yep. Tier 2, no upfront jail. So because I try to always keep notes on the plea and stuff. If it's a mandatory 5 years, then I have to place him on probation for 5 years.
I agree with that. Can I be provided with that specific statutory site? I know that there obviously are offenses where it's discretionarily up to 5 years.
Some are, okay, so those are for general, but is there, Mr. Jones, I know there's a list. Michigan.
Yeah, I have a packet here. I'm trying to find if I can give you an exact number.
I've seen it. Let's see here. Okay, so I got Michigan length of probation. We will get you that information, Mr. Dagger-Margosian.
That's fine.
And Mr. Jones will find that and share that with us. All right, anything else you'd like to say on behalf of your client?
I guess just on that length issue, if the clerk would just reserve imposing that until we know one way or the other. But no, I don't have anything else at this time.
All right. Mr. Vanzo, is there anything you want to say on your own behalf?
No, ma'am.
Okay. All right, in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been set upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, and vindication for the law, potential for reformation, and the protection of society. So, Mr. Vanzo, obviously, Mr. Dagger-Margosian will be provided the information on probation terms, and if he wants to bring this up to address again, he can do so. He could just meet with Mr. Jones and I, but I'm going to place you on probation for a period of 5 years. There's $750 in court costs, $130 crime victim rights fee, $68 in state costs, a $60 DNA fee, a $30 per month supervision fee, 60 if we have to use a tether, which probably isn't likely. You are allowed to have contact with minor children if an adult is present and supervising. Unsupervised contact with your biological children is allowed. It should be noted that the mother of the victim in this case has requested a no contact, so you're not to have any contact with KV. Do you understand that? You're not to violate any criminal law of any unit of government. You must attend and complete sexual abuse prevention programming when referred to by Mr. Jones. You cannot work, live, or loiter within a school safety zone defined as 1,000 feet of school property unless you meet a statutory exemption. You can't go or be within 500 feet of parks, municipal swimming pools, playgrounds, childcare centers, preschools, arcades, or other places primarily used by individuals age 17 or under without written approval by Mr. Jones. You must register as required by the Michigan Sex Offender Registration Act and comply with all the requirements of that act. You must provide a completed copy of the Michigan Sex Offender Registration Form to Mr. Jones on your first in-person report following. Okay, so you have to provide that. And then you also have to, this doesn't make sense. Okay, so you have to register as a sex offender and keep that updated. And then understand that anytime you move, change your address, you have to update it, right? And then
I've already met with Mr. Jones and paperwork.
Yep, and you gotta make sure you stay up on that.
Yes,
If you fail to do that, that's a new crime. Okay, you can't leave the state without consent of the court. You are not to use any illegal controlled substances. You are supposed to test as required, truthfully report to the probation officer as he requires, whether that's monthly in person or writing or however he wants.
Yes, ma'am.
You can't use or possess any drug paraphernalia as well. Can't use any object as a weapon. If they have reasonable cause to believe you have items that might violate the conditions of your probation, they can search your house, your phone, your computer. Do you understand that? All right. Anything else, Mr. Jones?
Judge, I got a number for you, a statutory number.
Oh, yes.
Looks like MCL 771.210.
210.
Well, it's in parentheses of 10, so 771.2 and then 10 in parentheses. And just to make it easy, it looks like listed offense, meaning a tier 1, 2, or 3 offense in the Sex Offender Registration Act. A defendant who is convicted of one or more of the following crimes is not eligible for reduced probation. But I mean, it goes on to all of it. I have a packet of it all.
Judge, I'm also looking at 771.2A, where there are exemptions. If Mr. Vanzo meets one of those exemptions, I will coordinate with the court and go.
All right, so you do have the right to appeal the sentence. My bailiff's gonna hand down to you your notice of right to appellate review. He's gonna have you initial and date one copy for my records. The other copies are for you, and if you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days, all right?
Judge, he'll need to report Tuesday morning, please.
Do you want him to come over now, or?
No, because I got to get the terms of probation and get you to sign it, and I won't have that today.
So Mr. Vanzo, you need to report to Mr. Jones next Tuesday morning at 8 o'clock.
Yes, Susan?
All right. Okay, very good. Thank you. And the record should reflect I received back the signed copy of the notice of right to appellate review. And Mr. Noe, we just need Mr. Sala.
Yeah, you stepped up, I think you put a document down the hall.
Okay, perfect. All right, Mr. Degan-Bogosian, do you have anything else?
I'm all set. Thank you, Anna.
Okay, all right, and that concludes our criminal docket.